All right. Well, hello, everybody. This is Greg Herrman. It is Frequently Asked Question Friday again. We're going back to our old format a little bit. We're going to do a question and answer today. One of my lawyers here, Daniel Covich, is going to answer some questions. Daniel, you want to tell us just a little bit about yourself?
Sure. Good afternoon. My name is Daniel Covich. I'm one of Greg Herrman's litigators here at Herrman Herrman. Originally from Austin, Texas. I've been down in the South Texas area here in Corpus Christi since 2000. Graduated from what is now Texas State University in San Marcos. Attended the University of Oklahoma Law School.
Boo, Oklahoma.
Boo, Oklahoma. I got my UT transfusion. I came back and went to work for the University of Texas as an adjunct professor at the University of Texas Law School, where I taught second and third year law students. Worked for Cornyn when Cornyn was Attorney General as one of his assistant AGs. And I'm fortunate enough to be litigating down here with and for Greg.
Okay, so we were going to talk about HIPAA, but that sounded a little bit boring, so we decided to switch up the subject a little bit, and we're going to talk about the Texas law, which makes it a felony for teachers and students to have sex, even if the student is over 17, which if y'all don't know, 17 is the age of consent in Texas. Some states it's 18, some states it's lower, but Texas it's 17. So, but not for the law. It'd be okay for two consenting adults because 17 is considered an adult. Not for the law, it would be okay to have sex relations. But this is kind of a big thing right now. It seems to happen all the time. It seems like about once or twice every month I hear about another teacher and student having sex, and so Daniel fashions himself some kind of an expert, or a little bit of an expert on this subject, so I thought we'd just ask him some questions about it.
What a loaded question. What a loaded statement. I'm no expert on that.
All right, so what should our audience need to know about this law?
Thank you. What's very interesting about this, Greg, is that Texas has this somewhat unique law that is actually being challenged right now, that basically says, look, although the age of consent may be 17, if you're a teacher, you have a special relationship and duty to your students, and even if they're 17 or above, we're going to make it a felony because of that relationship for you to have an improper sexual relationship, any type of sexual relationship with a student. What we're finding right now is the challenge that's going on to actually the Supreme Court of Texas on this law is similar to the challenge and the argument that was being made for the prohibition in various states across, especially the South, for same-sex marriages. One of the basic premises to fight the same-sex marriage bans is the argument that it is a violation of people's basic constitutional rights to pick and choose as they feel. Irrespective of how you feel about that, that's the law, and that's the argument against the law. And what is going on right now with the challenge on the statute in Texas regarding teachers and 17-year-olds and making it a felony is the same. Whether or not that specific law that makes it a felony is unconstitutional because it interferes with what would otherwise be a legal relationship.
Yeah.
So that's what's going on with that. What's also very interesting to me is
I would think maybe that students are a special class, so that could be classified separately, and there's a reason to treat them differently than just a regular person in society.
Well, yeah, and that's when you start getting into society values and norms and what the morals are of any given culture, because I don't know about others, but I send my kids to school to get education, and I'd like them to come back basically in the same condition they were when I sent them. And I think that all societies, I don't care what religion it is or what country you're from, or even what time period you're talking about in the history of mankind, all societies expect teachers to take care of their students and not engage in sexual conduct with their students.
So that would seem to me a difference between the argument about same-sex marriage.
Absolutely, yeah. That you are dealing with somewhat naive young people. I have to say that in a lot of these cases, what you see is very predatory behavior on behalf of these teachers, where they absolutely know that these kids are 17, down to their 17th birthday. We have seen cases here at Herrman Herrman where you have teachers engaging in relations with kids a week after they turn 17. Is that coincidence? Maybe, but we doubt it.
Yeah.
We doubt it's coincidence.
And that's a case you're handling here at Herrman Herrman?
Yeah, it's one of them.
Okay.
And we see it a lot.
We have more than one of them?
Yeah, we do. Yeah, we do. We've got a couple. Okay. And what's interesting, Greg, and we've talked about this before, is that the double standard there is in our society regarding a male teacher versus a female teacher. I've seen cases and involved with cases where you're talking about a female teacher with a male student. In one case, it was a female teacher with an African-American athlete, male student. And you have to wonder if you turn the roles around a little bit in our society, if you'd been an African-American teacher with a blonde-haired, blue-eyed cheerleader, whether or not there would have been a little more criminal punishment on that,
of course.
as opposed to the high fives.
Yeah.
So that's what we see a lot of, and that's something that really does need to be addressed nationwide. There needs to be some consistency in the laws. You just seem to see a lot of female teachers with this type of behavior across the United States. I personally think that part of it is that there's the lack of penalty when it comes to female teachers.
So you think it'll be a federal law then as opposed to a state law?
There needs to be some uniformity in the law, and usually uniformity comes with a federal statute. That there should be some sort of act or law that makes it more uniform and consistent for female teachers.
Right. So. All right, and I understand so there's a lawyer challenging this law in front of the United States Supreme Court?
Yeah, there is. And
he's a criminal lawyer, or he's a civil, or it's a criminal case or something?
It's a criminal case. Now, he does handle the civil side of these cases also, but what those two attorneys are doing is they've represented a teacher or some individuals that have been prosecuted under the criminal statutes, and they're taking that up, the criminal side of that, up to the United States Supreme Court, basically saying, for the same reason you cannot ban same-sex marriages, you cannot interfere with what would otherwise be a lawful relationship. And we're kind of full circle back on the fact that these are kids, they're kids, and their society expectations for this. And I think their position is, look, go ahead and take my teaching certificate away. I can't teach anymore. Go ahead and take that from me, but don't send me to prison for what otherwise would not be a felony. And that's what their argument is before the U.S. Supreme Court.
And so, but the cases we're handling are civil cases.
Absolutely.
And what's our cause of action? And who are we're suing the teacher personally, or we're suing the school district, or how does that work?
Great question. Great point. A little of all the above. And whenever you have these situations, one of the things that we do as a firm at Herrman Herrman is we look very hard at what are the probable recoveries? Where can we get the best result for somebody? Somewhat similar to a surgeon. A surgeon goes in and just tries to decide what procedure or surgery would be the best for a patient. We have to look at what would get them the best result legally. And while there might be a criminal cause of action for the teacher's conduct, that same action could also be a civil cause of action. So on the criminal side of it, it might be the state of Texas versus whomever. It would be our kid or our kid's parents on behalf of that child versus whomever in the civil case for the exact same act. So they can be like two parallel train tracks at the same time. You can have the criminal going on and the civil case going on.
Now, let's say the kid's 17. Does he still need a parent to represent him?
Ironically, yes. Isn't that ironic that at 17 they're old enough to otherwise, if they're not in a teacher-student relationship, to engage in sexual relations without penalty normally, but you're not old enough to sign a contract for representation or to get a gym contract for that matter, to go join a gym, whatever it may be, until you're 18. So it's a little ironic there, but yeah, we would need their parent's signature to go forward for them. What does that tell you about whether or not they're still kids?
Yeah.
They're still kids.
And is this a 1983 action, or what's the cause of action?
It's not a civil rights cause of action per se. It's really more of an assault cause of action and or an invasion of privacy cause of action. What we tend to see with these types of things, unfortunately, is all the things that go around and along with this type of behavior. For example, you might have a minor a 17-year-old go to a teacher's house and be served alcohol or be served some other drug. And that in and of itself, taking the sexual conduct out of it is egregious behavior. So when you're dealing with someone's home, one of the things that we look for at Herrman Herrman, for example, might be homeowners coverage. If you assault a minor on your premises, if you give a minor a drug or alcohol and you're serving them underage or illegally, then that could be actionable under their homeowners policy. You can certainly sue the teacher, you can sue the individual that's behaving in this conduct, and their homeowners coverage may apply, and we've been successful in that in the past. But to go after, let's say, a school district is even harder than going after a normal employer. Like if you work for ABC Company and the manager or supervisor from ABC Company sexually assaults you or makes an improper advance, then that is all you have to show is that that company knew that this individual had a propensity to act this way, that they had things in their past that showed that, hey, this is not the type of person that you want wearing your company uniform, engaging with the public. This is the type of thing that you knew they did or that you should have known that they do because of their history. That is the same standard for the school district, but school districts have some like super immunity. It's very difficult to get to a school district as opposed to a private company. But in this type of instance, when you're talking about sexual conduct of a teacher with a student, there's definitely some precedent, some prior cases that allow you to hold the school district accountable and responsible for this behavior.
All right, well, first question, going after homeowners insurance, how do you get around the intentional conduct standard that insurance companies say we don't cover intentional conduct, we only cover negligent conduct?
And great question. And one of the things that you absolutely have to start with anytime you're talking about any type of homeowners insurance is, contracts 101, right? From the first day of law school, give me the contract, let me look at the relationship, the rights and duties between the parties, and I'll answer your question. Let me look at that contract between the insurance company and their insured, and I'll tell you what the rights and responsibilities are and whether or not there's coverage. Oftentimes, and I know that you've seen it over the years, you get an insurance company shooting you a letter, and in the body of that letter, they quote 2 or 3 sentences out of an insurance policy to try to explain to you why something isn't covered. But if you'd gotten a copy of that entire policy, you'd see that that language maybe was taken out of context. So it's very important that a homeowner allow us at Herrman Herrman to take a look at that insurance policy for them in total, so we can advise them accordingly on what their rights are and what the responsibilities are of that insurance company. It's very important that we do that. But putting that aside, to answer your question, most definitely the intentional conduct part is difficult, but very, very often when you have somebody acting like that and they're under criminal pressure, criminal indictment pressure, very seldom do they say, you're right, you got me, I meant to break the law, I intended to do this, I intended to do harm. It doesn't happen that way. This type of person tends not to take responsibility for things in their life. So a lot of it is how we plead it and present it to the insurance company. Baby lawyers make this mistake a lot. You got to absolutely know when to do something as a lawyer and when not to do something as a lawyer. And one of the things not to do is to plead any intentional conduct in your letter to the insurance company. Is make it absolutely just the facts of what occurred and let that insured deal with his insurance company to let them know whether or not their conduct was intentional or negligent.
And when you do sue the school district, are there any kind of caps on your recovery?
Absolutely, yes, there are. And this is again where it gets interesting. And there's black and white, and then unfortunately there's gray. There's somewhat of a gray area here on whether or not there's a cap. But typically, when you're dealing with an With a school district, you're not dealing with necessarily a private insurance company. So the statutory cap for the individual can be $100,000 up to $250,000 for the entity. So if you can get an award or a finding of negligence or wrongful conduct on the teacher, it would be $100,000, and on the school district would be $250,000. Would be the cap. But that is going to be for non-economic damages mostly. So if you've got economic damages to go with it, if there's something else, let's say it's for example, if it's not a sexual assault, but let's just say an assault, or where someone is attacked and hurt by a teacher, and they're injured for life, if that affected their wage earning capacity in the future, that would have no cap to it. The soft damages, the mental anguish, the intentional affliction or negligent infliction of emotional distress, that would be capped at the amounts that we just discussed.
What about say psychological damage? And let's say the harm for life, would that count as economic damage if it led to some decrease in their ability to work in the future?
That's exactly a good question, a good point. Yes and yes. The psychological damage in Texas has to be backed up with what they call a physical manifestation of injury. There's a very sad case out of Austin against the University of Texas that unfortunately proved that point. You can have of course, a psychological injury, but you've got to have either a counseling bill to go with it, that you're going to need counseling, or an estimate for counseling that you need into the future. Or also, let's face it, that people can have psychological injuries to the point that they shut down physically. And if you have those types of medical findings in the case, then absolutely you can get around what they call those soft damages or soft cases.
Wow.
If you want to hear a little bit about that UT case, it's a very interesting case. What happened?
Well, we try to keep these at about 15 minutes. We'll
another day.
It's
a great case.
I would say if anybody has any questions, y'all can put them on our Facebook page or send us a message, or and we can answer them. Or if y'all know somebody that has this kind of case, you can tell them to write in and ask for Daniel and talk to Daniel, or me too, and I can get with Daniel about it. But again, we try to keep these fairly short. And if anybody wants to hear about this case Daniel's down to tell us about, perhaps he can write a blog on it or something.
It's interesting. It's excuse the pun, it's a sexy case.
Anyway, I think that's for now. Anything you needed to add or wanted to add, Daniel?
I really appreciate you letting me be on this with you. It's an honor, and it's a lot of fun. Thank you. Enjoyed it very much.
All right, great. All right, well, until next week, thanks again, everybody, for tuning in for Frequently Asked Questions Friday. We'll see you next Friday, 2:30.